Your spousal sponsorship file can be dead before an officer even reads it, not because of red flags, not because of weak evidence, because of a divorce you got years ago that Canada doesn't recognize. Which means under Canadian law, you're still married to your first spouse, which means your current marriage is void. Bigamous, refused. I see this all the time. People did nothing wrong except trust that a divorce is a divorce. Well, it isn't. Hi, I'm Bella Lee. I'm a regulated Canadian immigration consultant, and I run my practice, Landro Immigration, out of Nova Scotia. Spousal sponsorship is one of the immigration fields that I specialize in. And prior marriage problems are in the top 3 reasons files get refused before they are even read on the merits. IRCC is using AI-assisted triage now. Past visa applications, travel records, marriage certificates is all cross-referenced in seconds. The days of hoping an officer doesn't notice the gap between your divorce date and your travel history, gone. So if you have any prior marriage in your background, civil, religious, customary, even one you thought was unofficial, you need to understand what Canada usually requires before you sign that sponsorship form. Here's what trips people up. Canada uses a dual validity test for foreign marriages, and the same logic applies to foreign divorces. Part 1 is formal validity. Did the divorce follow the procedure of the country where it was granted? Was it registered? Did it produce a real civil document, not just a religious one? Part 2 is essential validity. Did Canada have jurisdiction to recognize it under our Divorce Act? That second part is where most people fall. Section 22 of the Divorce Act says Canada will recognize the divorce if either spouse was ordinarily resident in that country for at least 1 full year before the divorce proceedings started. 1 year, continuous, right before you filed, not 5 years before. If you and your ex were both living in Canada and you flew home for 2 weeks to finalize a quick divorce, that generally don't meet the test. You weren't ordinarily resident anywhere except Canada. There's a backup test, the real and substantial connection test from common law. You can argue you owned property there, ran a business there, had your whole family there, traveled back constantly, but a vacation to sign papers? Courts and officers have rejected that pattern repeatedly. This is where I have to be careful with clients because the conversation gets really emotional. A bare talaq, 3 pronouncements, no court, no registration is not recognized as a divorce in Canada. The Ontario Court of Appeal confirmed this in this case in 2022. Even registering the talaq with an embassy doesn't fix it. No civil oversight, no recognition. Now, and this is important, Pakistan and Bangladesh are different. They have the Muslim Family Law Ordinance. There's a written notice to the Union Council. There is a mandatory 90-day waiting period. If that procedure was followed properly, the divorce can be recognized. But you need the Union Council registration. You need proof that notice was served and the 90 days actually have to have passed. People remarry on day 60 and wonder why their sponsorship gets refused. A Jewish gets religious only. You need the civil decree on top of it. A Catholic annulment from a diocesan tribunal, religious only. Carries no civil weight in Canada unless your country folded canon law into its civil code, which most don't. The pattern is the same. Religious dissolution alone is not enough. You need the civil paper. If anything I've said so far sounds like your situation, book a strategy session before you file. The link is below. If you or your spouse is Filipino and was previously married in the Philippines, listen carefully. The Philippines does not have absolute divorce for its citizens, full stop. What's available is a declaration of nullity or an annulment under the family code. These take years through the regional trial court. They cost real money until you have the certificate of finality and PSA annotated marriage certificate. That's the Philippine Statistics Authority. You are still married in the eyes of Philippine law, and IRCC will treat you as still married. There's one exception from the Manalo Doctrine. if a previous marriage was between a Filipino and a foreign national, and a valid divorce was obtained abroad, for example, Canada, the UAE, or Hong Kong, IRCC will generally recognize that divorce, even if the Philippine court hasn't finalized its recognition petition yet. But if both spouses were Filipino, a foreign divorce doesn't dissolve that marriage on the Philippine law. And if you try to remarry in the Philippines, that new marriage is void there. It has to happen outside the Philippines. This is the highest stakes scenario in spousal sponsorship. Get this wrong and the consequences can extend beyond a refusal. Misrepresentation findings carry a 5-year ban. Quick check before I keep going. If you're watching this and thinking none of this applies to me, my divorce was clean, stay with me for the next 2 minutes because the cleanest looking files are the ones I see refused most often. And here's why. China changed its divorce law. There is a 30-day cooling period for administrative divorces. Couples file the paperwork, assume they are divorced, and never go back to the registry to finalize after the 30 days. The marriage stays intact. People come to me to file a sponsorship and have no idea that they are still legally married in China. Mexico and the Dominican Republic, the old quickie divorce route. If you flew there, signed papers, and flew home, that pattern routinely fails the 1-year residency test under the Divorce Act. Iran requires court intervention even for mutual consent divorces, plus registration with the National Organization for Civil Registration. Disputes over mahr, the dowry, can hold up finalization. Nigeria has a trimodal system: statutory, customary, Islamic. The customary and Islamic ones often have no written records, and there's a documented problem with fabricated high court decrees, which means IRCC scrutinizes Nigerian decrees hard. India. Court delays are well documented. People remarry assuming the decree is finalized when it isn't yet absolute. The thing is, every one of these has a pattern and every one of these is fixable if it's caught before you file. Here's what scares me most, right? Is not the people who knew about a prior marriage and didn't disclose it. Those cases are clear. It's the people who checked single on a tourist visa application 5 years ago because they were separated and emotionally over it, and then they file a sponsorship now, correctly disclose the prior marriage, and IRCC system flags the inconsistency. That's Section 40 of IRPA, misrepresentation. A finding can carry a 5-year ban from Canada regardless of how genuine the current relationship is. The federal court has been consistent on this. The innocent mistake defense is extremely narrow. The duty of candor is absolute. Materiality is judged by whether the fact could have induced an error, not whether it actually did. So if you ever filled out a Canadian immigration form and got your marital status wrong, even by accident, even because you genuinely believed you were divorced, that's a conversation to have before the sponsorship goes in, not after. A few general paths people take. If a foreign divorce is shaky, failed the residency test, failed the real and substantial connection test, one option is a fresh divorce in a Canadian provincial court. It adds time, it adds cost, it also removes the question. If a divorce is technically valid but complex, old customary dissolution, religious decree integrated with civil law, there is a route through a Canadian provincial superior court for a declaration of marital status. The court formally affirms the foreign divorce. For people in an undissolvable marriage, Filipino spouse mid-annulment, refugee with no access to home country, there is a humanitarian and compassionate pathway under Section 25 of IRPA. It's hard, is not for everyone, but for the right facts is there. And for anyone who previously declared themselves single on a Canadian form when they shouldn't have, that's something to address head-on with a sworn affidavit and a clear chronology before submitting anything new. If you have any prior marriage in your history, yours or your spouse's, book a strategy session before you touch the sponsorship forms. The cost of working this out on the front end is nothing compared to what a refusal or a misrepresentation finding costs. Link is below. Thanks for watching. I'll see you in my next video.